Well, good afternoon, everybody, and welcome to the AFCA Superannuation Forum for the 3rd of April 2019, and hello to all of our attendees on our webcast as well. It's fantastic to be here. I'm June Smith, and we're really looking forward to having a chat and a conversation with you as part of our forum going forward. We want to share with you our experience of the last 5 months in handling superannuation complaints and in some of the issues that we're seeing and some of the insight that we might have for you about your internal dispute resolution as well. Before we start, may I please acknowledge the people of the Gadigal country, the Eora Nation, as the traditional owners and custodians of the land on which we meet. I pay my respects to their elders past, present and emerging, and pay my respects to my own elders of the Karenji Nation, who are the traditional custodians of the land where the Murray meets the Darling. If you haven't met us before, our panel today is Di Ennis, EGM of Resolutions. She is your best friend at AFCA, so if you don't know Di, please meet her. The wonderful Pam McAllister, our Ombudsman Superannuation, who's one of the decision makers and who is a key lead in developing the approaches that AFCA will take in superannuation, and Lisa Bacco as well, the Senior Manager for Superannuation, who runs the day-to-day operation of our superannuation teams, who are growing and who are getting bigger. Look, we've got so much to share with you today. I won't hang around. Who watched the budget with me last night? I'm not the old sad lonely lady, the only one. Okay, so you'll know that there were some announcements for AFCA last night in the budget, and we will share them, and we know there were some announcements for you as well. So in that context, we will raise the legacy dispute program and how that will be run. We will talk to you about the rules consultation that we are currently undertaking in relation to our ability to handle those complaints, and we want to have a conversation with you about some of the evidentiary and other interchange that we might have during the course of running those legacy disputes as well. Di will give you a snapshot, 5 months, on the statistics we have to date on the complaints that we've seen and the trends in superannuation complaint. We will give you a small snippet of what we anticipate our approach will be post-Royal Commission activity, bearing in mind that we live in what could only be described as a fluid environment when it comes to the political landscape in Australia as well. And Pam will lead our conversation on our insights into internal dispute resolution. Lisa will help us with the case management process. We're happy to take your questions. We have Q&A at the moment that has been provided to us before the forum, but we also invite you to give us questions from the floor and to you on the webcast as well. My messages for the superannuation funds is that dispute resolution and the way in which the industry will address consumer concerns and redress loss when wrongdoing occurs will be one of our key conversations in 2019-2020. And that won't just be AFCA and the industry, that will be across the board. And in exploring the boundaries within which that redress and those conversations will occur, there will be much of a spotlight about what a fair and reasonable trustee might do, taking into account the law and indeed their own trust deed when making decisions. And in that context, we hope to have a conversation with you about what fairness might mean and how it would equate to community standards and expectations about how it would expect a superannuation fund to be operating, not only questions about what it can do under the law, but what it should do as well. And so we'll talk to you a little bit about that today. Now, Di, I think it's a good time to start the conversation by giving a broad framework of what the complaint stats are looking like, not only how many in the door, but how many are getting referred out as well, and I'll leave that to you.
Thanks, June. Welcome, everyone. And apologies for a Presentation on statistics straight after lunch. I know it's really hard to focus after lunch. Hope you've all had double espresso. I had mine earlier this morning because I delivered these similar stats because we had a banking forum this morning. So what I'm going to do is run through some overall statistics for AFCA and then focus on your industry. So, by the way, if anyone is on the webcast and they want to ask questions, there is a little tab at the bottom of the webcast which says ask a question. Sorry, couldn't see that. And there's also a resources tab, so if you want to link on anything while we're doing it, there's also a technical support number, which is the 1800 733 416 if you're having any problems on the webcast. So the first 5 months, it's been a little bit busy. It's been a little bit busy across all sectors. And there've been some unexpected surprises. 30,000 complaints virtually in the first 5 months at AFCA. When we launched on 1 November, we foreshadowed and projected that we'd have 55,000 complaints across AFCA. So we're going to be well exceeding that projected target. It's possibly going to be more in the realm of 70 to 80,000 complaints at AFCA because we're steadily receiving about 6,000 to 6,500 complaints a month. Where are we receiving them? 61% are predominantly banking and finance product related, 22% GI, and this industry, the superannuation industry, comes in third at 9%. We didn't expect that. We thought that there'd be about 5% of superannuation complaints when we looked at previous data from the SCT and we looked at history of complaints data through what they'd seen. So the unexpected consequence for us is a significant increase, in fact more than double the volume of superannuation complaints than we expected. The good news is that 55% have been closed. So we've received just under 30,000, but we have actually closed 55% of them. And I'll go through in a little bit more detail how that's occurred in terms of where they've closed. But the wonderful news is that AFCA has facilitated through its complaint resolution service $67 million worth of compensation back to consumers where financial firms have made an error or done something that shouldn't have occurred. If you have a look, small business disputes are just under 2,000 and we had an increased remit on small business, and 36,000 AFCA members are active and may well have a complaint, but we've only got 11% in terms of those members. So, sorry, I didn't make that very clear. So we've got 36,000 members and only 11% of those 36,000 members had a complaint or have had or still have a complaint with us. So if you're one of those lucky 11% sitting in this room or at the end of the webcast, then I suppose what you've got to look at is how you can avoid being in that lucky percentage and you can try and resolve those matters before they come to us, because ultimately that's the ideal world and what we would like to see. Systemic issues, we've had 81 of those. Of those 81, 6 have been relating to superannuation. They've been in relation to failure to advise about rights to go to EDR, disclosure issues, delays in switching funds, and potential breach of a fund. We've had 13 serious contraventions under RG 267 across the whole of AFCA. Superannuation has had 1 to this date, and that related to a breach of the SIS Act. So it's been a pretty active space. I'm going to run through some of the key issues and themes across all the product areas, and while some of the product areas don't relate to superannuation, the issues and themes are interesting because when you have a look at this slide, it shows you credit. So the issues here, there's incorrect fees and charges, misleading product or service information. In terms of investments, service quality, incorrect fees and charges, inappropriate advice. If you have a look at the next slide, which is some of the banking products, again, incorrect fees and charges, life insurance, denial of claim, incorrect premiums, delaying claims handling, and also service quality with the deposit taking again. So you're seeing a theme across all the different product areas about the issues that consumers feel their financial firm can't address, either when they go and talk to them first or when we refer the matter back to them to try and resolve before we have to deal with it. Again, payment systems, service quality, incorrect fees and costs, general insurance, delaying claims handling, denial of claim and service quality. It really is, when I was looking at these last night, I thought, you know, the themes are really coming through about what industry possibly isn't understanding that consumers need better explanation of, or what they're not really grappling with at the moment post-Royal Commission. What you're all really here to know is superannuation, top 5 complaints and issues. Incorrect fees and costs. So we didn't anticipate that this would be a significant volume of complaints previously, because when we looked historically at the volume of complaints that had fee and cost issues that had gone through the SCT, it was really quite small. But a little thing called the Royal Commission, where there's been a focus on some of that, and I think consumer expectations, consumer understanding about why fees are being charged is at a low, and so there's a lack of trust, and we're seeing complaints because of that. The other one, delaying claims handling. So delaying claims handling you'll have seen through the life insurance and the general insurance well. In terms of the delaying claims handling, one of the things that my question to you is given what's been out in the media about responsiveness to consumers and dealing with their matters when they come in the door, what are the issues that is causing consumers to come to us to complain about the fact that they haven't heard or there's been a delay in that? So there's some of the things that you need to have a think about. And generally what we find with delay in claims handling is often it's a question of resourcing. It's, are your areas that are dealing with those claims, or are the IDR or EDR areas adequately resourced to deal with the volume of complaints that are coming in the door? So all up, complaints received for superannuation was just over 2,500. When I talk about complaints received, what I mean is it's complaints that come to us at registration. So we register the complaint. They either come in because they've been through your IDR and they're not happy, or they've not gone to your IDR for a number of reasons. Some of them are they've tried to talk to individual people at your organisations and they haven't got the answer they've wanted, so they've not gone into an IDR area, they've just gone to whoever it was they were talking to, didn't get a satisfactory answer and came straight to AFCA. A complaint, and Pam's going to touch on this a bit later too, doesn't need to go through your IDR area to be categorised as a complaint. In terms of the complaints received, 55% went through IDR and 45% went post-IDR. So when I say they came through IDR, what I mean is 55% of the complaints that came to us at registration had not been through your IDR process. So they went through our IDR process at Reg, where we just refer them back to you. So my challenge to the room and to everyone listening on the webcast is that's a high number. How can you get your member, you call them a member, your customer, coming direct to you without the need to go to AFCA? So it might be about how quick and easy it is to access, how to log a complaint on your website. It might be your numbers, how accessible they are. It might be the way you're dealing with your customer at the time that they come back to you. They might come back with a query, but actually they're complaining and your staff aren't picking that up. So what we'd like to see is that, in theory, we would hope that most consumers come to us after they've been dealt with by the relevant IDR area of a financial firm, and that's across all industries, not just superannuation. So just over 2,500, we get them in the door and then we refer them back to you. So what this slide talks about, and at forums going in the future, we will always refer to these slides. What we talk about is what's your known closure rate. So how many of those matters do you actually resolve at registration that don't need to go through to the case management process? So if you have a look here, we've got them by different product groups, BF, GI, IL, Super, and they're rated in order of performance. Across the board for AFCA in the month of February, it was 35% of all complaints that were referred back, irrespective of product group, actually ended up resolving. Generally, in legacy predecessor schemes, that number has often been over 50%. But where you're looking at with your industry, you'll see the dots that start November 18, and unfortunately had a fantastic start out the gate, if I'm using horse racing technology that I don't understand anything about. June knows more. Yeah, it's a jump. Okay, so you jump out the gate. Okay, thanks, June. I need to get teaching. And it's just progressively gone down. So in terms of the volumes that were resolved in February was 13%, which means that 87% of complaints will have to go through our case management process, which is, in terms of industries, I understand that this is a new process for the superannuation trustees and that you're trying to find your feet with how it all works. I also totally understand that a lot of you are also juggling superannuation complaints tribunal runoff as well as new AFCA world, so there's challenges all around. But often when we see a trend like that, it does indicate to us, do you have enough people in your teams to actually deal with the volumes coming through your doors? And I think the challenge for every one of us, and that includes AFCA, is that there have been unprecedented volumes, they're not going away, and resources are key. And we're resourcing up, which I'll talk about in a little bit later, but it's what we'd expect you to be doing too. So we've referred it back and 87% have come back to us. So we've accepted just over 1,300 complaints into superannuation, and those complaints then get reviewed and we try and work out whether they're fast track, standard or complex. And Lisa to my left oversees all of the fast track, standard and complex complaints. So all those, how many did I say? 1,400 odd complaints, which is why she's probably looking a little bit tired. So she's got 4 teams and they work out what to do with those complaints. Now the challenge is we also track where those matters progress, because at the time that they progress into case management, they should either have your IDR response if it didn't previously go through IDR, or your EDR response if it's a post-IDR complaint. And what we're seeing in your industry is that 23% of those complaints that then move through to case management have no IDR or no EDR response. So we're trying to stream complaints based on what the consumers come to us on the online complaint form, and that can be really challenging to work out whether it's a fast track, a standard or a complex complaint. So what we would like to see is 0. Often some of the best performers are between 0 and 5%, because there's often issues where you've got staff ill or those sorts of things, people go on unexpected leave. But having a quarter of the matters that we allocate to caseworkers with absolutely nothing on the file from the trustee is really challenging for us, because it's really hard for us to engage and pick up a phone with a consumer to have a meaningful conversation about what their position is and what your position is. And it's also, to be honest, not a really good look that you've also not even responded to us on time. And it gives them the wrong message about what importance you place on their complaint. So where we've closed things. One of the statistics I normally look at is where we've closed things in case management 1. So if you have a look here, it's 29%, so 332 cases actually closed at case management 1. And the challenge for you is, how can you manage to get them closed earlier in registration? Are they the ones that we didn't get a response on? What can you do? So if you go back to your businesses today and have a look at what could we do to get our results better at AFCA, that would be the first place I would look in terms of what could we have done differently to get a resolution over the line before the matter needed to progress. We totally appreciate sometimes matters do need to progress into that level and close where there's an offer but there's a lack of trust, or you're not really on speaking terms with your customer because there's been a parting of the ways and people are entrenched, and sometimes it needs us as an independent third party to come in there and say, look, we think that their position's pretty sound, but you know, they're the ones that I would go back and have a look at. The other thing that to have a look at, we have closed 9 at decision. We've actually issued 8 decisions, and all of them have actually affirmed the trustee's decision. There've been 4 fast track and 4 standard and complex. So, you know, we are getting through those volumes. In terms of outcome type, which I just mentioned, this tells you what the different outcomes are. 10 have resolved through conciliation, and we've had some really positive feedback about use of conciliation from some of the superannuation trustees, which has been really lovely, thank you. And I think the other thing is we've had feedback from some of our caseworkers that matters they thought would not resolve, or there was, you know, real challenges with finding a resolution pathway, actually did resolve. So it's a great experience to go through that, and we've got a webinar coming up shortly about conciliations on the 17th of April. So if any of your team, I know SCT previously did them, but if you're resourcing up to get new staff and they need to do that, they'll be able to log into the webinar or do it later on when they start. So use that as, it's a sort of how to be involved in a conciliation. The really good information though in terms of these outcomes is if you have a look at preliminary assessments in favour of the financial firm as well as decisions of the trustee accepted, what it does demonstrate is that you've been doing a great job in resolving the ones that don't need to go through to a decision and also to a preliminary view, because where we are giving a view, it's in favour of the financial firm. So I think that what you're selecting to settle and what's going through to decision, you're doing really well on that. So that's a really positive message. On some of the other slides, what people wanted to get a feel for in some of the feedback we've had in liaison groups is how many went through fast track, how many went through standard, and how many went through complex, bearing in mind that all death benefits go through complex. So what you'll see in the fast track space is a lot of closed at case management 1. A lot of them are fee complaints. So it's how can they get resolved a bit earlier, and I think, Pam, you're going to be talking a little bit about that later in the session. Does anyone have a question on statistics or any of the information we've got? Because then I'm going to move on to processes and procedures, but I'm happy to take anything. Perfect. What I'm going to do now is talk a little bit about some changes, upcoming changes across the board at AFCA. The first one, which everyone's been discussing and a lot of people have got uncertainties about in terms of volumes and how it's going to impact people and documents and what process and how will this all play out, are the complaints dating back to 1 January 2008. So the Treasurer announced in the government response to the Royal Commission that AFCA would have its remit expanded to consider those matters that matched actually the Royal Commission timeframe. So the 10-year remit that the Royal Commission was looking at, that AFCA could go back that further period. Under our rules as they spoke, notwithstanding that the Treasurer said people could immediately come to AFCA, we actually didn't have the power in our rules to do that. We now do, our authorisation conditions were amended on the 19th of February, and AFCA can now handle these complaints, but we can only handle them between 1 July 2019 and 30 June 2020. There's one exception. We can handle them if you consent prior to that date. So if we get a complaint that would fall within this remit in the next few weeks, if you consent to us looking at, we can deal with it. I think most of you in the room will hopefully know, and on the webcast, that we're currently undergoing a consultation on the amendment to our rules that take into account these authorisation conditions that have changed. Whilst the authorisation conditions are pretty much set in stone from the Treasurer, we would encourage you to really have a look at the rules and the operational guidelines to work out if you've got any questions or queries about how we've incorporated the wording into our rules, and also the guidance that we've given about how we're going to deal with some of these matters. There is some guidance about documentation when that might be lacking, because I know that's been a concern, and also if there's information that's just not available. So I know that's also been a concern. In the link on this document, and for those of you on the webcast in the resources page, you can access the consultation paper, the draft rules and the operational guidelines. Next Friday, the 12th of April, is the final day to make submissions, so I encourage you all to have a look at it and then put your submission into the relevant email address, which is here. So you've got till Friday, you've got this weekend, guys, to have a look at them all and make your submissions. So what we're wanting to do in relation complaints dating back to 1 January 2008 is we want to seek your consent so we can look at them now. We've actually put a new case section into the Secure Services portal that you can access as members, which means that we're a bit more proactive about dealing with those in the extended time frame. What we don't really want to do is have consumers coming to us, which they have been, saying, look, we can't unless there's consent. We ask for consent and have to say go away and come back on 1 July. It just seems a futile exercise. We've been gradually doing that as things have gone, progressed from February onwards, and we're finding really a really positive view from members about providing that consent. What we'd also ask you to do is, if you happen to get a complaint into your IDR area that hasn't come to AFCA, that falls within this remit, that you also take a really proactive approach and have a good look at the complaint. At the end of the day, we would like to see a lot of these legacy complaints resolved by the financial firms. The best experience for your customer is to have you resolve them first up as soon as they come in the door. So particularly with these legacy complaints, what you can do to resolve them is really appreciated, because I think that it's going to be a much better experience for people concerned. We do understand, though, that some of those complaints may well have been on foot for a long time, and there will be a need for those to come to AFCA. The other thing I'd like you to also think about is a lot of the matters that progress into our rules area, where we assess jurisdiction, progress there because a financial firm has disputed jurisdiction with the specific case action in Secure Services. Please have a look at the matter and work out whether or not it would fit within the legacy matters, so that if it is partly in under the current BAU AFCA, but there's an aspect that's out, have a talk to us, pick up the phone, and if you're happy for us to look at it, we'll look at the whole thing. I just think that we've had occasions recently where members have objected, part of the complaints in, part of the complaints out, and it's not a great experience to be writing to say, well, we're only going to look at this, we're not going to look at that. It really is not the intention of what the Treasurer put in the government response and what we'll be dealing with. Some other things that will be changing at AFCA, there's going to be more transparency and accountability about reporting and information on what we see as a result of complaints being lodged with us. Those changes are in line with the broader sentiment of the Royal Commission, the regulatory guide RG 267, and there's also the consultation that's going to be starting about IDR reporting with ASIC in relation to regulatory guide 165. What those changes mean for you is that from 2019 to 2020, currently under the AFCA rules, if we publish a decision, we will de-identify the financial firm. That's under Rule A 14.5. But from the next financial year, we'll be naming financial firms in those determinations that we will be publishing. We'll be coming out to consult with you in late May, June, and we'll be discussing and hearing what your thoughts on that is, but there's a commitment from AFCA's board, that there is to be more transparency and accountability. In terms of systemic issues, we'll also be reporting on definite systemic issues. Under RG 267, we have to name financial firms to ASIC when we report a definite systemic issue and a serious contravention. We will also be publishing more broadly in a suite of our reporting where a financial firm has had a definite systemic issue, what that systemic issue is, and who the financial firm is. So that will commence from 1 July. The other change that will be coming out shortly and will be engaging with you very soon by email is the changes to the AFCA comparative reporting, or really the inaugural AFCA comparative reporting. Legacy schemes had comparative reporting, but there are slightly different requirements under RG 237, and we will be now reporting raw complaint data, which is received by the financial firm and by the product group, and we'll continue to include business sizing metrics based on your information so that there's a comparability based on business size. With the predecessor schemes, it was chance of a complaint coming to the legacy scheme, but in this case it will actually be the raw number of complaints coming. We'll also be reporting on that every 6 months, not every 12 months, and that'll come into effect in the 18-19 comparative reporting, which is published in October 2019. One thing to remember, I think comparative reporting is quite different for superannuation trustees. You've not had reporting in this way, and we're happy to talk to you about how that might present. You can give our membership line a call. There'll be a lot of information on the Secure Services portal as to what it means. But the two legacy schemes, FOS and CIO, had previous comparative reporting. What AFCA has agreed is that comparative reporting this year will only be published for AFCA complaints, so complaints that were received from 1 November onwards. The presentation will be sent out to everyone, and Claire will make sure it's got all this information in it. So the final thing I just want to cover off is fees and levies. So as you know, superannuation with the transition to AFCA there was a discussion around how the fees would be charged, and it was decided with a transitional costing model to pretty much keep the model of a levy, which was how the Superannuation Complaints Tribunal was funded. But as you can see from our original complaints and the volumes coming in the door in those initial slides, we've recently considered whether we've got sufficient funding. That's because we've had a whole heap of extra complaints. We've got a new jurisdiction in terms of remit. We've had a significant increase in those complaints, which has meant we've had to resource up, grow, and we've also had to respond to the Commission. We've actually put on 250 operational staff in the last 8 months. So we're doing what I'm and AFCA is asking you to do is be adequately resourced. It's equally important for us to be adequately resourced to make sure we can deal with the complaint volumes that are coming into AFCA. And we're currently tracking at about 42% higher than any of the predecessor schemes, with no sign of that reducing. In March, we had the second highest month of complaints received. So, as everyone knows, if you put on 250 operational support, you need IT, HR, computer systems, everything upgraded, and we're now across 3 sites. We've outgrown our site in Melbourne, so we've got another satellite site in Melbourne. We've got a site in Sydney, which we're also expanding and having to take further floors and looking for more accommodation. So the board was very mindful in their decision to look at and review case fees and levies that we would take a user pays approach to it. So it's the 11% of people that have got those complaints out of the 36,000 members that will wear the majority of the increases. So user pay system. So in terms of AFCA fees and levies, the user charge, which is for non-super, and the complaint fees, which is for non-super, will increase, but superannuation levy will also have an increase by a proportional amount. We're currently working through that. We know all of you are probably going to work out your budget for the next financial year. We're aiming to get it finalised as soon as we can. We will be posting information on our Secure Services portal. We're aiming to have the budget settled in June with our board, and then we will confirm the increases as soon as the budget's been settled. But if you've got any queries, please feel free to call our membership line on 1300 565562 or shoot membership an email. So happy to have the conversation, but it is something that we really need to address, given superannuation complaints have more than doubled than what we originally projected it and based our original levy on. I think that's pretty much all from me, but if anyone's got any question, I'm happy to answer, unless, June, you want to forge ahead with your Royal Commission.
There's a question online, which is very helpful. Dana asks, our experience so far has been that allowing people to lodge their complaint with AFCA before an IDR is giving members the opportunity to skip a step. As with most people, they want to fast-track their complaint or inquiry. Can you tell us, Di, and suggest whether or not there be a requirement that a complainant complete an IDR process before it can be accepted at AFCA? And I know you've covered that, but can you just repeat that?
The referral back process came out of the Ramsay review. That was reinforced because it was a pre-existing process in the legacy schemes, and it was re-endorsed by the Ramsay review. It's really here to stay. And I think what it is members having the resources and set up to deal with those matters and also identify when something is actually a complaint. I think that is one of the issues from some of the feedback we're receiving, and I know, Pam, you're going to talk about this, is it really a complaint, and should you be addressing it as a complaint so that they're not then coming to us? But it is here to stay.
I think everything you've said, Di, ties nicely into the discussion I now want to have with you about the post-Royal Commission activity. And we can talk about the impact that that commission has had on the operations of industry and on the law reform that may or may not come. But I just want to talk about a customer focus for a little minute. And for me, the overarching outcome of the Royal Commission was actually around culture. And having a PhD in cultural and organisational decision making, the one thing I can always spot within an organisation is whether it has a customer-centric focus or whether it doesn't. And the first question I ask is, tell me all about your complaints handling processes. And if I hear answers that are defensive or that remind me of a litigation strategy, given that I was a past litigator, or are aggressive, or are head in the sand, then I know that's telling me an awful lot about the culture within that business. Because the most significant thing about culture within an organisation is actually how it handles the bad times, and in particular how it will address and redress consumer concerns. And when we are looking at how the government has responded to the post-Royal Commission activity and some of the programs that we've been given to operate, everything from the compensation scheme of last resort through to the unfunded liabilities payments, through to the amendments to Section 912A, for me, they actually go to how does the financial services sector itself engage with consumers who have concerns? Does it take a proactive and genuine engagement model that puts the customer at the centre of that and tries to resolve it, or does it do something else? And so one of the frames of reference we will very much have this year under our AFCA strategy is our opportunity to influence the way in which dispute handling occurs within this sector. And in particular for all of you, we will be using these forums, we will be publishing guidance, we will be delivering training, we will be looking at the measures that Di just spoke about, including, for example, the number of complaints that we're seeing in the sector, how many are being resolved at registration and referral, the proactive engagement, indeed, of members at IDR and EDR as well, and whether or not that engagement is not just proactive but genuine. And I think we saw out of the Royal Commission some examples of behaviour where some financial firms had not engaged genuinely with their what is a legal obligation, their EDR obligation, and therefore we have the amendment to Section 912(1)A related to reasonable cooperation. Now, we may not need that amendment in the context of our handling of superannuation complaints because we already have some compulsory powers in relation to compelling information and talking to witnesses and the like, but we absolutely will use 912A amendment across the rest of the business. And so my call to arms, if you like, when you are engaging with ASIC and APRA in relation to what IDR looks for all of you, is to think about the culture piece first before you think about the process, the rules and the procedures. And if there is, and all of you have the opportunity to do that, and you're strategically positioned to do that because all of you manage or have oversight of or control or influence the dispute handling within your organisations. And so Di's talked to you a little bit as well about how we might handle the legacy complaints, and we're happy to have that conversation with you going forward. But I also want to talk about remediation programs because, as you know, there are many proposals at the moment about what AFCA's role might be in the remediation space. So I'll give you a little bit of insight into what it looks like right now. At the moment, we've played a consulting role with many of the larger firms in particular that have established remediation programs after the last four or 5 years. And that means we consult on design up front, and in particular, we're asked what would the AFCA approach or the FOS approach have been to the way in which we should identify whether or not we have caused loss to the consumer, either how are we liable for that loss or how much should that loss be. So if, and we don't wish this on you, but if you are designing a remediation program, we invite you to talk to us when you're talking to the regulator around the design of your program. And that's because what we all want to see is a consistent approach in the handling of those matters where wrongdoing has already been accepted, and so that the consumer, if they come to us when we independently review decisions you may have made, will not get a different response to us to the one that they have had from you. And in that sense, our second traditional role has been to be the independent reviewer of the decisions made by firms about whether or not a remediation payment should be made or not. And in that context, if you're setting up a remediation program, that might start with the communications you have with those members of your funds who might be within scope, and putting it up front and being transparent about the fact that if there has been wrongdoing and you are trying to make good, if the customer is still not satisfied, they have the right, indeed the entitlement as an extension of your service, to have an independent view from AFCA. We're very happy to help you with how you shape that correspondence, and we're very happy to walk you through the process that we would adopt in doing that independent review, because it is not business as usual. The consumer does not have the onus of proof in those matters. What we do is we look at the decision that the fund has made and we say, do we think that that decision was the right one for that particular client? And if we don't think it is, then we can step in and make a different decision. You know then that there are currently proposals that our role in fact be extended and may include that we have an oversight role over those remediation programs, and we report back not only on progress of those programs but also in terms of outcome. Whatever our role is, it's my personal hope that there's greater transparency around remediation programs that occur within the sector, and that firms step up and are accountable and understand that remediation programs will form a pivotal part of the way in which consumer concerns are addressed and redressed going forward. A pivotal part of the dispute resolution obligations that you will have will be the way in which you identify where wrongdoing has occurred and proactively and genuinely engage with those consumers and groups of consumers to make good. And we feel so strongly about this that over the next year we will be looking at our own role in remediation and how we can more actively and proactively engage with industry on that as well. So that's what I wanted to say about the Royal Commission activity. Are there any questions in relation to that? Just another call out then about the compensation scheme of last resort. If remediation schemes are about individual accountability of firms related to redress, then the compensation scheme of last resort is about collective accountability across the sector to ensure that any consumer who has suffered loss as a result of misconduct within the sector actually receives compensation as well. So when that scheme is set up, I would like all of you to take that lens to that scheme rather than thinking of it as just an added levy or just an added burden. Pam McAllister, I think it's time we talked decisions. I think it's time we talked insights into the issues that we're seeing in the complaints that we've had, and in particular, what is our approach going to be to death benefits and to other key issues going forward? Absolutely.
Is there going to be subdivision of the sector between industry funds, corporate funds, retail funds, or is the not-for-profit sector going to be expected to provide compensation for profit-making funds that go under?
Well, that's a matter for the government. At the moment, the proposals around scope are everything from it's just financial advice to it should be the whole sector. What we know from last night is that there's some money to Treasury and some money to AFCA to establish that compensation scheme of last resort, and in terms of the scope, I imagine that will be one thing that will happen once that scheme, we have more meat on the bones in relation to the scheme as well.
Thanks, June. Well, as Di has said, one of the changes brought about by AFCA assuming responsibility for superannuation complaints from the 1st of November 2018 is that there is no longer a hard-coded jurisdictional constraint, as there was for the Superannuation Complaints Tribunal, against accepting complaints that weren't already put through the 90-day internal dispute resolution or IDR period. That was a deliberate change. That said, AFCA's process when we accept or register a superannuation complaint is to refer the complaint back to the trustee. This is because, from our perspective, our main focus is to see complaints resolved, and if trustees can do it themselves without our assistance, then so much the better. The way that referral back process works is that if something is still going through the internal dispute resolution process, then we will refer it back either for the full 90 days or the balance of the process that hasn't yet expired. If it has already been through the 90-day internal dispute resolution process, then we will refer it back usually for a shorter period. The exception is death benefit complaints because of the statutory time constraints around the claim staking. But for others, we will refer it usually for a 21-day period, again, to see if resolution is possible. And in these cases where we do the 21-day refer back period, what we're really asking you to do is look at the complaint again with fresh eyes. That's really your opportunity to see if, in your previous consideration of the complaint, there is another perspective that you could look for. Or, for example, if, let's say, it's an insured benefit, another opportunity to engage with the insurer and see if the insurer might be prepared to take a different perspective. So that's really the purpose of that period. Then, of course, if you aren't able to resolve the complaint, it will come back into us, and then we will start to look at it using any tool that we can in our alternative dispute resolution armory. So that would be negotiation, it might be conciliation, it might be offering a preliminary view. But note that in that alternative dispute resolution phase, when it's in case management effectively, what we're really doing is taking an inquisitorial approach, not an adversarial approach. So we might put suggestions to the trustee, have you considered this, have you considered that, in a spirit of genuine cooperation and trying to resolve the complaint. Unfortunately, we've had a couple of experiences recently where we've taken that approach and we had quite a defensive, aggressive response from the superannuation trustees involved, and that really isn't in the spirit of what AFCA's about. I'm not saying it's anyone in this room, but really just be mindful that when we make suggestions, we're really trying to bring to bear all the experience that we have as alternative dispute resolution specialists to try to resolve a complaint. If we can't end up resolving the complaint through agreement, which is essentially what that process is about, then we'll proceed to a formal decision, which is when our statutory determination-making powers come into play, which, as you know, are based on the SCT's determination-making powers and the fair and reasonable test that was in that Act and that it's been carried across into the Corporations Act for AFCA. So as Di said, our early experience is telling us that trustees are not well-resourced to handle IDR as effectively as they could be. And I wanted to put a little bit of flesh on the bones around those comments, because there are a few themes coming through here. The first one, which has already been flagged, is not recognizing complaints early enough. So when we're contacting trustees to see if they have considered a complaint at internal dispute resolution, we're often hearing in response, oh, we haven't yet had our 90 days. But the story that we're hearing from the complainant is a completely different one. The complainant might be saying something like, oh, I've been trying to get an answer from the fund since August last year. And so in those circumstances where the complainant is saying they've been complaining, it might be reasonable for us then to assume that that IDR period started from August rather than now when we first hear about the complaint. And in that case, we might say, well, why should the trustee get an extra 90 days now when they could have been considering the complaint already? So what's the problem? We think the problem is that trustees are not identifying complaints early enough. And just a bit of background to this, remember that when the AFCA scheme was introduced, at the same time, Section 101 of the Superannuation Industry Supervision Act, or SIS as we lovingly refer to it, was replaced with an obligation to have an IDR procedure that complies with Section 912A2 of the Corporations Act. That's the AFS licensee obligation. And if you look at that obligation, that's the requirement that you have to have IDR procedures that comply with ASIC's standards and requirements. And ASIC, of course, in setting its standards and requirements, is in turn required to have regard to the Australian Complaints Handling Standard. So if you look at ASIC's RG165, which I think is going to be consulted on shortly, but if you look at the existing version of ASIC's RG165, that sets out the requirements that it has for handling complaints at internal dispute resolution stage. It has adopted the definition of complaint from the Australian standard, as it's required to do. And that definition is an expression of dissatisfaction made to an organisation related to its product or services or the complaints handling process itself, where a response or a resolution is explicitly or implicitly expected. So if we go back to the example I gave before of the frustrated complainant, we think that trustees and their administrators might need to do a better job of capturing and progressing all expressions of dissatisfaction as complaints. Now, at RG 165, paragraph 80, ASIC does acknowledge that that approach could create an administrative or compliance burden, and they suggest a rule of thumb. And the rule of thumb they suggest is that if something's not resolved to a customer's satisfaction within 5 business days, then it should be progressed through the IDR process as a complaint. And we would encourage trustees to adopt that rule of thumb. So essentially, or another rule of thumb might be if it's the second time they've run up about the same issue and they're still unhappy, you might progress it through the IDR process. But all of these little tweaks and changes will hopefully mean that more complaints resolve at trustee level and that they don't actually need to progress through our system at AFCA. So that was the first thing. The second thing we've noticed is that sometimes where a trustee is part of a larger corporate group, a complainant might be mistaken about who they're meant to be lodging their complaint against. So let's say they lodge it against party A. And so we register it against party A and we start sending our emails out to party A. But in fact, the complaint should have lodged their complaint against party B within the group. And then by the time the complaint is recognised as one that should have been properly brought against Party B wants more time because they say, oh, hey, we haven't had our IDR or we haven't had our 21-day referral back process. But meanwhile, the complainant is kept waiting. So naturally, we're a bit unsympathetic to granting extensions of time in that situation. And again, that problem could be solved by someone within the complaints handling team at Party A, rather than just sitting on it, immediately recognising, hey, this belongs to Party B, and either contacting AFCA to let us know, in which case we'll change it on our system, or if it's within a group, just simply forwarding it on to Party B and saying, we've got this, we think this is yours. So some level of cooperation within a group might reasonably be expected, and that might even include, complaints lodged with an administrator, for example, or with an insurer, where, again, you might expect some cooperation. The third theme is, as Di has already mentioned, the resourcing theme. And something we're hearing back from a lot of trustees is your timeframes are really short. We don't have enough time to respond to your timeframes. For example, a request for information. Well, that's true because our timeframes are deliberately short, they're deliberately tight, so that we can keep the complaint moving, so that we can meet other expectations on us to be efficient and to resolve complaints in a timely manner. So yes, they are short. And what that means, of course, is that, as Di has indicated, you need to resource up. And we acknowledge that it's a double whammy at this point in time because you're resourcing up to meet requests for information from the SCT and you're resourcing up to meet requests for information from AFCA. But I guess the salient word of warning I would issue is that if you are repeatedly requesting extensions of time, that could be taken as a sign of inadequate resourcing, and it may even mean that you have a systemic issue. And given what we've spoken about with the systemic issues reporting obligations that we have, that's obviously something that you and your boards need to take on board. I'll just give you an example of our interactive approach. and the way we engage. And in this case, it was actually a successful engagement. So in a recent case, we were sending out requests for information to a super trustee. The complaint was that the person thought their insurance premiums should be refunded, and the trustee was saying, no, they shouldn't be refunded because you actually had cover. But then the trustee was unable to provide us with a correct version of the insurance policy, so we couldn't check whether that person did in fact have cover, whether they were eligible for cover, or anything like that. But meanwhile, they were still insisting that they weren't going to issue any refund. And this went on through several rounds of requests for informations and requests for extension. And eventually, we put it to the trustee that if they were unable to actually produce the correct version of the policy to show that the complainant was actually covered, then it was unfair and unreasonable of them to take an approach that they wouldn't refund the premium. Fortunately, in that case, the trustee did accept that position, and it made the refund without any need for the complaint to go on to a formal determination. But that's the way we would try to engage. It's not actually drawing an adverse inference in that case. It's just saying, if you can't show us how the person is covered, why are you refusing to give them back the money that you've taken from their account? And the final point I wanted to make under this general topic of themes is about the way trustees are communicating with essentially your own members, your own customers. As I mentioned, we are seeing a lot of complaints about fees and insurance premiums, and in many cases, these complaints are coming from people who were defaulted into a MySuper product by their employer. And so they've got a fundamental misunderstanding because they don't understand, how can I have insurance cover when I've never even applied for it? That's their common perception, because they might be outside of super aware that you have to actually apply to get insurance cover. So they don't understand, firstly, that their employer was required to enroll them in the MySuper product in order to meet the superannuation guarantee obligations, unless, of course, they completed a choice of fund form. Or two, that the fund is actually required in a MySuper product at the moment to provide them with death and permanent incapacity cover, unless they tell the trustees they don't want it. So they don't understand those two fundamental things. And in fact, our very first superannuation determination was about precisely that very issue. And we've had a few more since then. So imagine the frustration from a complainant in that situation when they receive an IDR response from the trustee to the effect of, you didn't opt out, so we're entitled to charge the premiums for the cover you received. The complainant doesn't understand the whole concept of being placed in a financial product by default, and they don't understand what opt-out means because they didn't understand why automatic cover was provided to them in the first place. So what are we going to do about that? We think trustees could do something about that by perhaps trying to speak more in language that a consumer would understand and not assuming that they know what the superannuation rules and regulations are. We think trustees could do a better job, but we're also going to do some things about that. We're going to publish a fact sheet on MySuper and insurance cover on our website to help educate potential complainants about the issue. We're also changing our letters that we send to complainants when we first accept their complaint and start investigating it, to try to explain in those letters about the issues of automatic insurance cover, and to try to point to them where it might have been disclosed to them that they had this cover and that they were entitled to opt out and what opt out means. And we're also going to, in our EDR response guide, include a new section for trustees that explains what we need from you to help us deal with these complaints. We need particular information that'll help us resolve them more quickly. Most of these are going through our fast track process at the moment, but we think we can probably resolve them even more quickly. So again, let's try and communicate with our fund members in a way that doesn't have assumed knowledge about the superannuation industry embedded in it. So the key learnings, just to repeat them: recognize and process complaints early, have a process to identify the correct party to a complaint, particularly within a group situation, resource to promptly respond to AFCA requests, and communicate with your members in a language that they can understand. So the next topic is our case management process. And we've had a couple of questions about this in advance, so hopefully this will help answer those questions. So once a complaint proceeds through our registration and referral phase, it will then go into our rules team to assess jurisdiction. The general rule that we apply is that a complaint is within jurisdiction unless it is clearly out. And sometimes we might need more information to assess whether a complaint is in or out. Assuming that it's in, or at least it looks like it's in at that point, a complaint will then proceed to case management. And at case management, one of three things could happen. As we receive more information, we might actually realize that the complaint was outside of jurisdiction. We call that OTR. And if that happens, we might make an initial jurisdictional decision, and there's then a process for the complainant to object to that and for it to be reviewed by a more senior AFCA staff member or even an AFCA decision maker. And if that objection is unsuccessful, the complaint will then close. So what that's telling you is that jurisdiction doesn't just happen up front. It happens throughout the process. The second thing that could happen is as we receive more information about the complaint, we might realize that it actually doesn't have any merit. And that might mean that either the trustee hasn't made any error, or alternatively that the trustee couldn't have made any other decision consistent with its rules and the law. And if that happens, we might do something called a case assessment. So again, we would issue a letter to the complainant. We would say, we think that this complaint doesn't have any merit because the trustee couldn't have made any other decision or something like that. And again, give the complainant an opportunity to object, to explain why that isn't the case. And again, that would be reviewed by a more senior AFCA staff member or a decision maker if that objection occurs. But if the objection is unsuccessful, the complaint would then close again. And then, of course, the third thing that might happen is as we receive more information, we might form a view about the fairness and reasonableness of the trustee's decision. That could be either after negotiation or it could be following conciliation. But in any event, at that point, we might give the parties what we call a preliminary assessment, either verbally or in writing. And if the parties accept our preliminary assessment, the complaint would then resolve by mutual agreement on that basis. If the parties don't agree, the complaint will then go through for a formal determination by an AFCA decision maker. So there's no compulsion to accept a preliminary assessment, and in some cases the usefulness of a preliminary assessment is it could highlight a key piece of missing information that hasn't yet been provided. So we find that's actually a really good process. There are some cases that won't have a preliminary assessment. We're already starting to see a couple of those. So if, for example, when we do that view about the fairness and reasonableness of the trustee's decision, we actually think there's been an error of law on the part of the trustee, there's no point issuing a preliminary assessment because nobody can agree to that. In that case, it will go straight through for determination. So a preliminary assessment is often given, but it's not universally given. And so we have seen a lot of complaints at the moment, I think because we're new and because we're shiny and because there's a lot of publicity about us, that we might actually end up trying to resolve by case assessment. So you might see that a little bit more in the future. We had an early determination which we did issue where one of my colleagues, Jane Abbott, made a determination about a $750 death benefit where the adult children wanted reimbursement for funeral expenses. Clearly, that's not probably something that in future should come through to determination. You'll see it there. I think it's up on our website. But that might be the type of matter where we might try to resolve something with a case assessment. And so the message is that this is evolving as we gain more experience with the multitude of superannuation complaints that we might see. You're likely to experience a variety of these processes, and it will always depend on the nature of the complaint. The next thing I've been asked to speak about is our approach to death benefits. We have produced this document here, and I think there might be some copies around the room. which is a brochure very similar to the approach taken by the SCT. And perhaps it's not surprising that we would take the same approach as the SCT in terms of death benefit complaints, because our review function is exactly the same and the law hasn't changed in that regard. And the purpose of a superannuation death benefit hasn't changed either. So we're experiencing similar issues to what I understand the SCT also experiences, such as complaints from adult children who are not financially dependent or interdependent on the deceased fund member. We're hoping that our approach document may help to either prevent some of these disputes or at least help resolve them. And in fact, we were able to successfully conciliate a death benefit dispute recently by referring to the approach document to help the parties come to a common understanding of what the purpose of a superannuation death benefit is. I also wanted to say a word about insured superannuation benefits and our approach. So we've received a large portion of superannuation complaints about insured benefits, and some of these types of complaints are set out there on the slide. Refusal to pay the benefit obviously is a key one. As Di's already mentioned, delays in claims handling, including requests for additional medical information. And we've even had a few complaints about underwriting decisions. So, for example, imposition of a pre-existing condition or loading or refusal to provide additional cover, those kinds of things. I wanted to say a quick word about underwriting complaints. The general rule is that complaints about underwriting are outside our rules, except if the underwriting decision was made on the basis of incorrect information or it was discriminatory. And that's actually set out in our transitional super guide if you want a bit more detail about that. But in order for us to work out whether one of those exceptions applies, again, that's a situation where we will need more information from the insurer about its underwriting process and any statistical data that it might have used. Not because we're going to question the actual underwriting guidelines, but because we need to understand what they are to make sure that they have been applied in a non-discriminatory manner. And we've had a couple of recent examples where we have had to ask an insurer for that kind of information so that we can then make the proper jurisdictional decision. Just like at the SCT, there are strict time limits that apply to the bringing of a complaint about a disability decision. Essentially, these time limits are not in the legislation, but they are in our rules. So it's 2 years to bring a claim to the trustee and 4 years to complain to AFCA if the reason the person ceased employment was disablement, and it's 6 years to complain to AFCA otherwise. And we cannot extend those time frames because they are under our rules, although we could ask a trustee to waive them because, again, as Di pointed out, we do have the ability to consider complaints by consent in such a case. So if someone was a day out of time or something like that, we might ask you to consent. Other complaints like delays in claims handling or underwriting complaints, the general time frame there is 2 years from the date of the IDR response. And we can, of course, extend that time frame in special circumstances because it's a discretionary time limit in that case. So when would we join the insurer? I'll say a couple of words about this and then I might just pass briefly to Lisa because we have had some initial, let's call them teething problems with our approach to joining an insurer and at what point we should do it. So just like the SCT, we have the statutory power to join the insurer to a superannuation complaint about an insured benefit, and we would generally do so whenever the insurer is involved in the underlying decision. And then if we join the insurer, we can consider the fairness and reasonableness of both the trustee's decision and the insurer's decision. As a matter of process, we open 2 different files, so you might see different file numbers, but they are linked, and there would be a single determination, just like you would have experienced if you've had a complaint at the SCT. And we can also determine that interest is payable if there's been a delay against the insurer under Section 57 of the Insurance Contracts Act, if it was the insurer who was responsible, or at the earning rate if that the member would have earned on their account if the trustee was responsible. So what we've decided to do is slightly vary the way we are registering complaints against trustees and insurers, and I'll just pass over quickly to Lisa to just explain the slight adjustment that we've decided to make.
Thanks, Pam. So we have a challenge where we're relying to a degree on the complainant to tell us who the party is that the complaint's against, and often for a superannuation complaint about insurance, they will raise the complaint against the insurer. We can't accept a superannuation complaint against an insurer, so we then need to identify who the trustee is at that point. Sometimes the complainant gives us enough information to understand who the trustee is, and sometimes they don't. They might just say, insurer A won't pay me my TPD benefit. So what that's a challenge that we have, and what we're doing in terms of our registration process is tweaking it slightly so that that complaint against the insurer doesn't continue to progress without a trustee being identified up front, because that then leads to situations that Pam talked about before, where we may end up having a complaint go some way through our process, particularly if the insurer doesn't tell the trustee that they have the complaint, and then we then have a complaint that reaches us in case management, and we're now finding out that the trustee is saying they don't know about the complaint. We're having to give the trustee their IDR period, which is then prolonging the time before we can look at that complaint for the complainant, which is adding unnecessary angst, and of course they don't understand why the delay. So what will be happening going forward is if a complaint is raised against an insurer, we will be making best endeavours to identify that that's, and it's a superannuation complaint, we'll be making best endeavours to identify who the trustee is up front. We will be doing that by either calling the complainant themselves to see if they understand who their superannuation fund is and who their trustee is. We may also call the insurer to ask the insurer to tell us who the trustee is. And what we'll do then is we'll change the name of the financial firm that complaint is raised against to the superannuation trustee. The trustee will then receive notice that there's a complaint being raised against them. At that point, we would be expecting that the trustee will be engaging with their insurer and saying we have a complaint about Mr Smith's claim, and would be going through its normal processes, be it the 21-day refer back period post IDR, or whether it's the actual full 90 days IDR period or balance of. The thing that I would stress there is that we do expect that the insurer and the trustee will be talking to each other through that process, and from my personal experience in working in that area, I would actually find it quite difficult to understand how a trustee could actually review a complaint about an insured matter if they weren't engaging with their insurer at that point. And the reason I raise that is because we are finding when something comes through to case management that the insurers are also saying to us, well, this is the first time we've heard of this. When the case has been with the trustee, we know the trustee's dealt with it through their IDR period, and the insurer is saying, well, we think we need additional time because we don't know about this. And my response to that is I actually think that that's impossible, because the trustee must have dealt with their insurer to be looking at the complaint through the IDR process. So we will be trying to identify as quickly as possible that it's a trustee complaint and not a complaint against the insurer in the first instance. If we miss that at registration, we would ask that you ask your insurer if they do get a complaint brought against them and it's for one of your members, to let you know as soon as possible. Our view, and it goes back to Pam's conversation about when a complaint's received, I would suggest that when one of your service providers first finds out about a complaint, whether it's your administrator or your insurer, I would also suggest that that's when you're first finding out about the complaint, because of the relationship you have with those service providers. So if your insurer is finding out about a complaint and isn't letting you know about it, then that's potentially limiting the time that you as the trustee have to look at that case. I would be saying that the 90-day IDR period, if you haven't seen that complaint, actually would go back to when we told your insurer about that matter, because of your relationship with your insurer. So Hopefully, though, the insurers won't be the first point of contact. It will be the trustee. The complaint will progress through our case management through registration. And if it's not resolved in the registration and referral stage, it will come to case management. That's where we identify and consider whether it's appropriate for the insurer to be joined. So my team in case management will then raise a case, the second case that Pam was talking about, against the insurer. And we will engage with yourselves in the insurer to let you know that's happening. We'll also engage with the complainant to let them know that's happening and explain why that second complaint case has been raised. And then that's where the formal joining of the insurer, and so the exercising of our statutory power happens. But that's not going to happen until the case management stage, which is sometime down the process past registration and referral.
Can I also just add to that? What you may not know is 75% of our complaints come in online through our web form. And so often people are lodging them at all times of the day and night. And also in relation to superannuation complaints, you've often got people that are really struggling with life's issues. They're ill, they've suffered a family death, they've really got vulnerability issues as well. So for them trying to navigate, and we try and make our website as accessible as it can be, but for them trying to navigate with their insurer whether or not a TPD claim or a life policy or a death is meant to go through super or it's meant to go through just our general life insurance jurisdiction, it's incredibly difficult. We struggle sometimes ourselves trying to work it out, even when we've got the documents. So that's why that early engagement, so as soon as we get that online form and our staff check it off, it pretty much gets loaded. You get that email within an hour or so of that. That's the point when you get that initial email to be doing all the things that Lisa's talking about, because that's when you can make a big difference to get the right people involved and get names on files changed.
Yeah, and to Di's point, that's the time when you should be letting us know if we haven't perhaps got it quite right, or your insurer should be letting us know as soon as possible if they haven't got it right. The other time that we join, just if I could, Pam, is when death benefits. So we join individuals to death benefit complaints. So the complaint is raised by the complainant, and that complainant must have objected to yourselves. And then there's a process where people are invited to join the complaint. And then when it comes to case management, we assess whether the people that have been invited were in fact the appropriate people to be invited to join the complaint. And then we proceed to follow up on those invitations, and where appropriate we will join them. But again, it's at case management that the additional parties to the death benefit complaint are joined. So it's not at the early part of the process.
And can I also just add to that, the underlying policy of that is that hopefully you can resolve the matter so we don't actually need to get to a joined situation. So that's where there's no point joining at that point, because we're hoping with the referral back and with the claims taking period that it'll all get sorted out, because I know, sorry, it's not referred back for death benefit, but in that period you can resolve it and there will be no need to join.
And can I also just add one more comment about complainants who are making disability claims, and just to reinforce Di's point about vulnerable people. We've had an unfortunate experience recently where a complainant was suffering from a mental disability, and the insurer needed further information from the member's treating doctors. Now, under the life insurance code, there is a section of the code that says if the insurer needs further information, it will, with the consent obviously of the complainant, go directly to the treating doctors. For some reason in this particular case, the insurer just declined the claim and said that the onus was on this member, this suffering member, this vulnerable member, to go and get the doctor's reports herself, which she found very difficult to do because of the nature of her disability. We put it to the trustee when the complaint came to us that the trustee might consider going back to its insurer and pointing out this particular provision of the life insurance code. To our surprise, the trustee gave us a lot of pushback about that. and said, we're not signatories to the code, so we think it's fair enough. That type of approach is not going to wash at AFCA. I'm not saying it's anyone in this room. In fact, I'm pretty sure it's not. But that's the kind of thing that if we see that, going back to June's comment earlier about culture, that's really not putting the member first. So that's just an anecdote about what we don't want to see.
If I can also just add, in terms of consumers or your members that are vulnerable as well, or where you're struggling to complete IDR or to engage with them, one of the things is that you will generally know that at the time that the complaint walks in the door at AFCA. So the more you can let us know and give us the heads up, the more we can also sort through, does it really need to wait through the IDR process of 90 days or 21 days? Is that going to be beneficial? You know, there are people that are really in distressed situations, they're not well. We might be receiving 10 emails a day. When we start getting 10 emails a day, we know there's something not right. And so we can escalate and take that through our process in a slightly different approach. I know Lisa's had a couple of examples where we've just escalated it to the relevant area and we've tried to sort out the quickest way that we can work through the complaint. So sometimes for those sorts of matters, it actually isn't the best thing to just let them go through the process step by step, and you need to make sure it gets into the right hands, not just at your organisation, but also at our organisation, because I think those challenging behaviours can be very difficult. And the thing is, often they actually have a valid issue that they're concerned about. They're just struggling to express it, and our job is to unpack that and get to the bottom of it. So please give us a heads up when you've got something like that, because it really helps bring it to resolution much, much quicker.
So just finishing off my presentation then. So the last bullet points on this slide are where we get complaints about insurance premiums or disclosure. Now, we don't have any power under our rules. Again, there's an exclusion to actually look at the level of an insurance premium. But if the complaint is about non-disclosure of an insurance premium, then we will look at it. And we would usually, in those cases, proceed against the trustee, and we would only join the insurer, if it was actually necessary. If also the premium was incorrectly applied, we could also look at it. So you might get questions about that, and it's really us trying to determine whether there is an issue, as Di said. So as Lisa said, we don't have any power under the Corporations Act, which gives us our mandate for superannuation complaints. We don't actually have any power to consider a superannuation complaint against an insurer directly, except in two very limited circumstances, which are there on the slide. That is, if there's an annuity policy, we do have power to look at a decision of an insurer, or if the premiums for the policy were paid through a retirement savings account, we then have the capacity to look at an insurer's decision. Other than that, we have to go through the process, as Lisa described, of registering the complaint against the trustee who owns, if you like, the superannuation policy and joining the insurer. There is one exception to that where we will look at a complaint against an insurer not under our superannuation jurisdiction, but under our general jurisdiction, even if the policy is held within super. And that exception is where the superannuation complaint was out of time. It didn't fall within those time limits that I mentioned before for disability decisions. In that case, we will accept the complaint against the insurer, but the superannuation trustee won't be joined, because we don't actually have power to join the superannuation trustee. So in that case, if the complainant were to be successful, the insured amount would be paid under the policy to the superannuation trustee as the policy owner, and then usually the fund member would then need to make an application to the trustee for the release of that amount under the permanent incapacity condition of release so that they could get the money in cash. The test would then be whether the insurer's decision was fair in all the circumstances, because that's the test for our general jurisdiction. It wouldn't be fair and reasonable, because that's the test for our superannuation jurisdiction. And importantly, monetary caps would apply, because we have caps under our general jurisdiction, whereas we don't have any monetary caps for superannuation complaints. So that's essentially the approach that we take, and the reason we take that approach is because that's the approach that was taken by our predecessor scheme, FOS, and when the rules were formulated for AFCA, we took an approach of no one should be any worse off, so we encaptured all those things within the rules. Well, that's it from me. So we might open up from questions. Yep.
Claire, have I got a set of questions? So we did have some pre-submitted questions, but before we do that, does anyone want to make a comment or ask a question of the panel? Yes, hi.
When dealing with vulnerable complainants, what resources do you have available?
So when we're dealing with vulnerable complainants, what resources have we got available at AFCA? Who wants to handle that?
It's a very good question. We're actually in the process at the moment of getting some AFCA resources for our own internal staff. We've done lifeline training with our staff recently, and we've also engaged with a couple of organisations to come and talk to us about mental illness. We haven't, at this stage, got that capacity or capability. We haven't built that capability to come out and train AFCA members, but that's something that we can take on board. We're going through similar things with our own staff to actually get people up to speed with dealing with that. So there's a couple of really good organisations I'm happy to share with anyone, so I'll talk to you afterwards and happy to give you some of the organisations we've used.
And a person just there, you had a question?
Hi, thank you. I've got a question or perhaps a suggestion. I was very interested to hear about how the industry has to work better together in terms of insurers working with the funds to make sure they talk to each other so complaints can progress as quickly as possible. And I think there's a lot of improvement happening in that area already, but we're not quite there yet. So often from a life insurer point of view, the first thing they are notified of is basically that the case has progressed to management. At that point, unfortunately, there is no information about what the complaint is about or who the fund is that is involved. I'm just wondering if it would be possible at that time to be notified which fund is involved so the insurer can contact the insurer, because to date we've tried to contact AFCA and I've been told, well, we need to join you first, but unfortunately that information doesn't come through until perhaps a week or 2 weeks later. So if that could be changed, I think that would be really helpful to speed up the process.
Lisa?
Yeah, look, ideally what should be happening before that email is generated for the insurer, there should be a call to the insurer, to the contact of the insurer, letting them know that email is coming their way. So that's some great feedback, thank you, because obviously that's not happening all the time, so I'll take that back. No, that's fine, that's what we're here for. And you know, even if there were specific examples, I mean, that would be brilliant, because that then helps us even further. But no, in an ideal world, that we would be having a phone call and sort of setting the scene about why that email was coming beforehand.
Di, have we got any coming through on the webcast?
We don't, June. It's very quiet on the webcast. So anyone on the webcast, if you've got questions out there, feel free to put them in.
We're set to go. Pam, we've got a question about whether we've got a quick scenario where separated spouses are involved in a super dispute, but they're still legally married, where there are financial dependents and also current de facto partners. Lord, that sounds like maths to me. What approach would AFCA recommend?
Well, I like to get back to basics with these. So essentially, if you have multiple parties who all qualify as dependents and who are all financially dependent, because remembering that the purpose of a superannuation death benefit is essentially to replace the money that the dependent parties would have expected to receive had the deceased person not died and lived on into retirement. So that's essentially what the purpose of it is for. So if we look to, okay, what level of financial dependence did each of the potential dependents have? And then essentially try to determine that level of financial dependence and make a pro rata distribution of the death benefit according to that level of financial dependence. That's the approach that I would take. Now, in some cases, if it's a very small death benefit, maybe that isn't the approach, but if there's a substantial sum, I think that the approach is to do that pro rata depending on the level of financial dependence that's been shown.
Okay. Now, Di, we've got a question around how to have a discussion with AFCA if there are specific matters at reg and referral stage. What should a trustee do?
So if you've got a question about the process, then we've got on our Secure Services portal a list of all the AFCA contacts. So I'm going like this because it's an A4 page, and it's got everyone's phone number there from team manager to senior manager to EGM, the leads. And what I would suggest for registration, Stephen Short is the manager for registration. His contact details are there. And Jacinta Ryan is the senior manager across the registration and rules area. So if you've got queries and you're trying to understand how this whole new process works for you, then I would suggest Stephen or Jacinta as your first port of call if it's a bigger picture question. If it's an individual complaint matter about a registered complaint, then I would suggest that Stephen's your first point of contact.
And Di, can I just add, if it's about a specific detail, some sort of a superannuation related question in terms of law or detail of the complaint, happy for you to reach out to myself or my team managers as well, who are also included on that document that Di was referring to.
Okay, I hope that the person who asked this question feels it's answered, but Lisa, is AFCA taking the view that it can consider a complaint even if a complaint has been dealt with by the SCT?
I would say if a complaint has been dealt with by the SCT, then AFCA's view would be no, we cannot deal with that.
So the way we define dealt with means that there's actually been a finalisation, a resolution, a decision made. So if it falls outside of that, then it might be that there's jurisdiction, but if it is covered by that, then the answer would be no. Di, do you want to add to that?
If I can just add, in relation to the legacy complaints, that position remains unchanged as well. So those complaints going back to conduct on or after 1 January 2008, that's the same position. So that was carved out of that legacy remit.
And I just wanted to add that whether a complaint's been dealt with by the SCT can sometimes be a little difficult because complainants are clever and they might express the complaint in a slightly different way. So what we have to look at is whether the substance of the complaint, the subject matter of the complaint, was actually dealt with by a determination, let's say, at the SCT. So it's not always as straightforward as it might at first seem, but the rule is that if it has been dealt with by the SCT, the subject matter, then it is outside of AFCA's jurisdiction. There's not intended to be any double dipping.
No double dipping. So that's a no but. Interestingly, Di, we've got another question around complete autonomy in decision making. Di and Pam and Liz, you might all want to have a go at this one. Does AFCA have complete autonomy in its decision of whether to accept complaints, or is it limited by its terms of reference or rules or any guidelines?
Well, I might kick off because I saw that question, and that is why apps are fantastic, because I can't remember all our new rule numbers and I'm struggling. So under C1,
Why
of our
not?
rules. Oh, I know, I should be sleeping with this under my pillow. Under C, one of our new rules, they're the mandatory exclusions. So there are exclusions which we just can't. So complaints that fall within those mandatory exclusions we just can't deal with. And as I scroll over, under C2, they're the complaints that we've got discretion to exclude. So if you go to the rules and have a look at section C, then that lists those ones. And Pam, you may well want to explain that a bit more, because Pam was the author of our transitional guide to the rules.
Well, the only other thing I would add is that in addition to being limited by our rules, we are also limited in the case of superannuation complaints by the Corporations Act. And so if you look at section, I think it's 1053 of the Corporations Act, that sets out what complaints about superannuation we can accept. And so we can't accept complaints other than those complaints as superannuation complaints, including, for example, we can't accept complaints about decision of self-managed superannuation trustees because they are carved out under that section. So yes, so the answer is no, we don't have complete autonomy. We are both governed by the law and also by our rules. And an example that I could give of this came up quite recently was where someone tried to make a complaint about a superannuation trustee's decision in relation to other members, not in relation to themselves. And if you look at section 1053, it says that the complaint has to be about a decision in relation to that particular member. It can't be about what's happened to other members, even though this was a very well-meaning complainant, but unfortunately, it was outside of jurisdiction for that reason.
Are there any other questions from the floor? Di, are there any other questions online?
Online is very quiet.
Houston, do we have a problem? Is anybody out there? We just want to thank you very much for coming today. We want to thank everyone on the webcast, everyone in the room. We love doing forums. The reason why we love doing forums is that we want to share our insight into the sorts of issues we're seeing. And we feel we should be accountable for the decisions we make, accountable to you and accountable to your members. So we will give you insight into our decisions every time we come here. We want to be transparent about the approach, and that's why Pam has gone into some detail today, and please take away our approach to superannuation death benefit complaints. And you've heard that we will be doing guidelines in relation to default insurance very soon, and that we have tweaked our joinder process early on in response to feedback too. So if you have feedback on an individual complaint, ring us. Use the secured service portal information and make sure you find the right staff member. If you have feedback about how AFCA is going generally, not only use these forums, but please feel free to ring Di, myself or Pam to talk those matters through as well. The more conversation we can have, the more we can respond to your feedback or answer your queries. I think that's better than letting something snowball and letting it fester. After all, AFCA is a service for you and your members, and you should be using it. So we wish you bon voyage. We wish you a safe journey home, and we will see you at the next forum, I think in June or July. Bye-bye.